Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed.
No, he's suing her for what she said.
What he is suing about here are the 3 statements that were directed at him.
Yeah.
He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU, and he made it also
in Amber's name
to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion, but like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here, and I would object because I think making an argument not to you but to the cameras, it's disrespectful to the court and everyone's time, and it also threatens to undermine the integrity of this process and risk the jury being influenced by outside factors.
Well, it's his argument. I'll allow him to do his
Thank you.
Thank you.
Thank you, Your Honor. As I was trying to say.
Anyway, let's see if I get this started. Say it. Sup, y'all? It's me. It's your boy Asmongold. I already did.
There's no record evidence whatsoever that Mr. Depp ever saw any of the 3 statements about which Ms. Heard is purportedly suing him for $100 million. As Your Honor is aware, the elements of defamation are as follows. 1, publication.
That happened.
2, an actionable statement. With 3, the requisite intent. See Thorpe versus Sanders, 285 Virginia 476 at 2013. The requisite intent for defamation against a public figure is actual malice.
How's that?
That is, the statement must be made with knowledge that it was false or with reckless disregard of whether it was false or not. See Sanders v. Harris, 213 Virginia 369 at 372, a 1972 case. See also Jackson v. Hartig, 274 Virginia at 2019. Reckless disregard, as Your Honor is aware,
it still needs to be
not
louder.
Measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipsis. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts.
Anybody not happy with that? Too bad.
Publication. Unquote.
This is what it's going to be.
St. Amant versus Thompson, 390 U.S. Supreme Court, 727 at 731. Your Honor, the evidence shows that Ms. Heard cannot prevail on her claim because she cannot and did not establish that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation and reasonably believed that the 3 statements he made were true.
Yeah.
Ms. Heard presented nothing to contradict that undisputed fact. Ms. Heard has no evidence of direct liability because obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting that she has no evidence of direct liability and cannot prove actual malice by Mr. Waldman when making the 3 statements at issue.
No, he thought he was telling the truth.
It is undisputed that Mr. Depp did not make any of the 3 statements at issue in Ms. Heard's counterclaim.
Yeah.
Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated, or otherwise authorized Mr. Waldman to make the statements at issue.
Yep.
There is no such evidence on the record that Mr. Depp directed or otherwise authorized Mr. Waldman to make the 3 allegedly defamatory statements at issue in the counterclaims. Indeed, there is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else.
He's right about that.
For this reason as well, Your Honor, Ms. Heard cannot meet her burden of proving that Mr. Waldman was acting within the scope of his employment as our agency on behalf of Mr. Depp.
It's true.
Again, it bears noting that there's no evidence that Mr. Depp even saw the statements by Mr. Waldman until he was served with the counterclaims well into this case. It was more than a year after Mr. Depp filed his complaint and Ms. Hurd lost a series of motions to dismiss that she finally asserted her counterclaims, most of which have already been dismissed by opinion letter of this court. Whereas here there is no evidence of direct liability, Ms. Hurd must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions, or statements rather, of his purported agent, Mr. Waldman.
Yep.
Vicarious liability is by definition, quote, liability for the tort of another person, unquote. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Hurd must establish that Mr. Waldman himself committed all the elements of defamation. I know the court's familiar with this, so I'll try to run through it quickly. See Parker versus Carillon Clinic, 296 Virginia 319 at 332,
Oh, he's got the
2018
receipts.
case. Quote, vicarious liability is liability for the tort of another person. It necessarily follows that a claimant cannot make out a case for vicarious liability against an employer without first proving that the employee committed a tort within the scope of his employment. See also Roughton Pontiac Court versus Alston, 236 Virginia, 152.
Multiple precedents.
156. Which standard Ms. Hurd has not met? And Your Honor, we cite a string citation to cases from other jurisdictions, which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is Ms. Hurd's burden to prove by clear and convincing evidence, or ultimately, to prove actual malice by Mr. Waldman, not Mr. Depp. And while it is well settled law in Virginia, as Your Honor has pointed out last week, that an agent's knowledge can be imputed to a principal, and this is the Allen Realty Corp versus Holbert case, 227 Virginia 441 at 446. Ms. Hurd's counsel cannot cite any case law stating that a principal's knowledge is imputed to an agent. In other words, Mr. Waldman must have made the statements knowing that they were false or with reckless disregard as to whether they were false.
And he did not do that.
Mr. Depp's knowledge cannot be imputed to him.
He did not do that.
There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false. Indeed, Mr. Waldman did not even know Mr. Depp or Ms. Hurd at the time of any of the alleged incidents at issue, and thus had no personal knowledge of what transpired. And this is reflected in the trial transcript that Mr. Waldman met Mr. Depp first in October of 2016, long after the fact. Nor is there any evidence in the record that Mr. Waldman subjectively entertained any serious doubts about the falsity of the counterclaim statements. Quite the opposite. The evidence shows, and it's unrebutted, that Mr. Waldman had very reasonable grounds to believe, and he did believe, and will to his dying day,
Yeah, he still
that
thinks
Ms.
this.
Hurd's claim of abuse were patently false. Mr. Waldman testified at length about 29 witnesses he believed disproved Ms. Hurd's false claims of abuse. See the transcript at page 6008 through 6012, and I won't run through all of that. But his testimony that two trained police officers, Officer Science and Haddon, were called to the penthouse on May 21, 2016, and saw no signs of injury on Ms. Hurd's face, as well as, quote, Ms. Hurd's own witnesses who have testified in various forms at various times that there were no injuries to her face whatsoever between May 21st and May 27th, 2016, when she walked in to court with her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of the witnesses whom Mr. Waldman has cited, they include Laura Devanere, Melanie Iglesias, who, as Your Honor recalls, was Ms. Hurd's makeup artist, who decided to end any professional or personal association with Ms. Hurd.
How convenient. A lot of people do that.
Samantha McMillan, Hilda Vargas, Isaac Baruch, Trinity Esparza, Cornelius Harrell, Alejandro Romero, and Brandon Patterson, just to name a few. No reasonable jury could find that Mr. Waldman acted with actual malice in making the allegedly defamatory statements. He was not present for the alleged incidents. He has no personal knowledge of any of the alleged incidents. What Mr. Waldman knows is a product of the legal work he did, the sleuthing he did on behalf of Mr. Depp.
Yeah, he looked a lot of stuff up.
Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice, and her defamation claim must fail. 2,
Or that he was reckless.
Mr. Waldman is an independent contractor, not an employee. It is axiomatic, Your Honor, that a person who hires an independent contractor is not liable for the independent contractor's actions.
Yep.
See Sanchez versus Medicorp Health System, 270 Virginia, 299 at 344. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way to bring about that result. See Atkinson versus Sachno, 261 Virginia, 378 at 284. That's a 2001 case. An outside lawyer retained by a client in connection with litigation is an independent contractor. See King versus Dalton, 895 F. Sup. 831, Eastern District of Virginia, 1995, where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic
that would make
applies
sense
when it's an individual like Mr.
That would make sense,
Depp.
sure.
That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results, or to try to obtain specific results, but they do not control the means by which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject to professional obligations to exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client, a lawyer shall exercise independent professional judgment, unquote.
To separate him from Johnny Depp.
As a matter of law, an independent contractor, and Mr. Depp cannot be held responsible for any alleged tort by
He's got the sources.
his attorney, particularly for statements about which he was unaware until he was sued for them. Mr. Waldman testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Mr. Depp or none of his loan-out companies have issued him a W-2, and Mr. Waldman provides legal services to clients other than and in addition to Mr. Depp, and that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Heard. Mr. Waldman's statements, the third reason for which we respectfully submit the counterclaim should be stricken, is that Mr. Waldman's statements were protected opinion. And I won't run through all of that, but very briefly, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment.
Oh,
See
shit.
Gertz versus Robert Welchink, 418 U.S. 323.
Going back to the Constitution.
39. That's a 1974 case from the United States Supreme Court. See also Shacker v. Bufault, a Virginia Supreme Court case found at 290 Virginia 83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, unquote. and finding an accusation of deceit to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp, as Mr. Waldman was, to challenge Ms. Heard's version of the inherently controversial events of the parties' marriage. Just as Ms. Heard's lawyers were quoted challenging Mr. Depp. And Your Honor will remember the context of these quotes that were in a British tabloid, where Mr. Waldman's statements were buried well into article in which both points of view were clearly expressed. And Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as one of Mr. Depp's attorneys.
Might get the whole case thrown?
C. Chavez, 230 Virginia 112 at page 119, quote, "The most unsophisticated recipient of such a claim, i.e. any reader of the British tabloid,
yeah. And that's what it is, a tabloid,
made by a competitor against another, could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias," unquote. Yeah. Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view about events that he never claims to have witnessed, and there was no doubt about that.
Yeah.
Turning to the second part of the argument, which will be more abridged, Ms. Heard is not entitled to anti-SLAPP immunity. As a threshold matter, Virginia Code Section 8.01-223.2, which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019.
What the hell is that?
Provides in relevant part, quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false.
Okay.
Here, in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc. during periods when Ms. Heard claimed to have injuries, marks, bruises, etc. Such witnesses include, but are not limited to, Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, Officer Sines and Haddon, Officer William Gatlin, and former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are not solely relating to a matter of public concern, as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed.
No, he's suing her for what she said.
What he is suing about here are the three statements that were directed at him.
Yeah.
He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU, and he made it also
in Amber's name
to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion, but like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here, and I would object because I think making an argument not to you but to the cameras, it's disrespectful to the court and everyone's time, and it also threatens to undermine the integrity of this process and risk the jury being influenced by outside factors.
Well, it's his argument. I'll allow him to do his
Thank you.
Thank you.
Thank you, Your Honor. As I was trying to say,
anyway,
what Mr. Depp is suing about are the three statements. And it's very clear,
Sit back down.
despite the pious opening statement that about the First Amendment, that with the testimony of Terrence Doherty and the emails that were admitted as exhibits, that the ACLU and Ms. Heard were conspiring to make it very clear that those three statements were related to Mr. Depp, because otherwise
Yes.
nobody had any interest in the article. And it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of any
Importance.
significance in terms of popularity.
Her role, too.
And to do that, that's very clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146. Instead, the defamatory implication at issue in each of the three statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard, which does not rise to the level of a matter of public concern with broader implications for society beyond the two litigants in this action any more than Mr. Waldman's statements. I mean,
Here we go.
adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the three statements that they very intentionally and very cleverly
They were about him.
Put in to make it clear the implication that it was about Mr. Depp.
Obviously.
They had lawyers from the ACLU working around the clock with Eric George to be as clever about this as possible. And Your Honor,
it wasn't very clever either.
Of Mr. Doherty about the consternation at the ACLU when they realized that USA Today and everybody else who read the article knew darn well that this was about Mr. Depp. This cannot be protected by the anti-SLAPP statute. It is a cynical runaround. And I think now that we have the undisputed evidence from the ACLU in the form of the testimony of Terrence Doherty, who's not only their corporate representative, he was their general counsel. He is a brainiac lawyer. They knew exactly what they were doing, Your Honor. And one of the, he referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Heard, and he expressed no concern about that. Now, that was either because
I wonder
they
why.
knew about, that was either a reference to this game they were playing with the op-ed, or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way. Simply stated, Your Honor,
oh my God.
Mr. Depp is not suing Ms. Heard for making statements about society in general. I think that's very clear from the record evidence.
It gets
Mr.
worse.
Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name. An act that, coming from an ex-spouse, is fundamentally personal in nature.
Absolutely.
For that reason as well, Your Honor, Virginia's anti-SLAPP statute is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you, sir. Yes, sir.
How do you even follow that up? Like, this is, I mean, that was bad.
As Your Honor knows, the trial court is required to accept as true all the evidence favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom which would sustain the counterclaim. That's the correct standard here. I'll address the actual malice argument first, the agency argument. Your Honor, there's plenty of evidence in the record from which the jury could determine that Mr. Waldman was Mr. Depp's agent. He made those statements. The statements referred to him as Mr. Depp's attorney. As Your Honor ruled on Friday with respect to the jury instruction conference, an attorney is an agent of his client.
The article
Mr.
wasn't
Waldman
written by him.
Testified that he's been Mr. Depp's attorney since 2016. He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer question after question about that agency, so he can't use that as a sword now.
Refused.
Mr. Chu puts a lot of
Attorney-client
emphasis
privilege.
on the fact that Mr. Depp allegedly didn't see the comments that were made that are the subject of the counterclaim. But as Your Honor well knows, whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with the Daily Mail with Mr. Waldman prior to the defamatory statements being made and released. I believe that was in February of 2020, just 2 months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD. He disregarded any evidence that he didn't believe would fit in his narrative, that would fit in this story that he was speaking about on behalf of Mr. Depp. And after Mr. Depp lost the UK proceeding, after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding,
He wasn't ruled to be a wife beater.
There found him to be a wife beater. Mr. Waldman then got an overseas
That's not what they
tabloid
said.
to run a story claiming that Amber was being investigated for perjury, which simply wasn't true. He walked into the LAPD, filed a complaint for perjury against Ms. Heard, found a media outlet that doesn't follow the two-source rule, and then he had let the world believe that the LAPD was investigating Ms. Heard for perjury. That's a shameful and a sickening example, Your Honor, of the lengths that Mr. Depp, through his agent, Mr. Waldman, would go to smear and to defame Amber Heard, and that continued in the 3 statements in the counterclaim.
We already talked to
Your
his
Honor's
agent.
heard evidence. I won't go through all the evidence, but Your Honor's heard evidence from Ron Schnell, who's traced the negative hashtags toward Amber Heard online associated with those defamatory statements, and noted the staggeringly high number of them that were associated with Mr. Waldman. Under the principles of the agent-principal relationship in Virginia, Your Honor, when Mr. Waldman made those statements, he was standing in the shoes of Mr. Depp. They are one and the same for the purposes of those statements. As Your Honor discussed at length on Friday, Mr. Waldman made these statements with actual malice. There's plenty of evidence from which the jury could infer that, and his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless disregard of facts that didn't support Mr. Depp.
There's a lot of
His attempts
evidence.
to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor denied Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's marriage and still made the statements at issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the jury
He had no
can,
knowledge?
and we believe will find.
But he knew all the people.
So, Your Honor,
By memory.
there's no basis to grant a motion to strike on this agency argument, on the actual malice argument. The evidence shows that not only was Mr. Waldman Mr. Depp's agent, but that the two of them conspired to falsely accuse Amber of creating a hoax and falsify evidence that they believed supported their,
where's
their
the evidence?
theory and what they wanted to achieve. As Your Honor well knows, too, I won't go through all the law, but both agency and malice can be inferred through circumstantial evidence. There's plenty of evidence in the record from which the jury could infer those. Moving on, Your Honor, to the independent contractor, the court's already rejected this argument. Ruled that an attorney-client have a principal-agent relationship, and as Your Honor said on Friday, there's no evidence in this case of anything otherwise. As to the argument that the counterclaim statements are statements of opinion, the court has already found twice that they are not statements of opinion, both on January 4th, 2021, in its opinion letter denying Mr. Depp's demur as to the counterclaim statements, and at the motion for summary judgment hearing in March of this year. As to the anti-SLAPP argument, the court again has already ruled at the March 24th, 2021 opinion that the statements are, as a matter of law, regarding matters of public opinion. The court has already ruled that. Therefore, the only remaining issue for anti-SLAPP is whether the intent element of immunity is met. as we discussed on Friday, the intent element of immunity is substantially the same as the actual malice standard.
Okay.
Which the evidence in this case easily allows a jury to find in favor of Ms. Heard on that. I won't go through the litany of evidence that supports that Mr. Depp is an abuser here, but I'll touch on a few things that relate to Mr. Chu's argument. One, Mr. Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring to achieve a defamatory implication to Mr. Depp. That's simply not what Mr. Doherty said. Mr. Chu's feel free to argue that to the jury, but that's not what his testimony reflects.
Yeah,
Your
I
Honor,
wonder.
there's also
I bet it is.
plenty of evidence that's been adduced both in Mr. Depp's claim and in Ms. Heard's counterclaim that show that absolutely that the counterclaim statements are 100% false. There was no hoax perpetrated. Mr. Depp is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, some of the evidence that's come up since the last motion to strike, Your Honor, that Mr. Chu conveniently disregards in his brief are the testimony of Rocky Pennington, the testimony of Josh Drew, the testimony of Elizabeth Mars, all of whom completely corroborate Ms. Heard's account of the events of May 21st, 2016.
No, they don't.
The testimony of Melanie Iglesias, who testified that she covered Ms. Heard's bruises with makeup right after the December 15th incident that provided ample testimony to support that Ms. Heard often would cover her bruises that were caused by the plaintiff, in this case, by Mr. Depp, with makeup. He ignores the evidence of Christy Sexton. He ignores the evidence of Io Tillett Wright. He ignores the evidence of Whitney Enriquez.
What evidence?
All of these witnesses and others have testified extensively about Mr. Depp's abusive behavior.
That's
toward
not
Ms. Heard.
evidence.
Physical abuse, emotional abuse, psychological abuse, verbal abuse, Your Honor. Mr. Depp's own writings, recordings, pictures, and videos confirm that. The list goes on. There's abundant evidence in the record, Your Honor, from which the jury could, and again, we believe will find that Ms. Heard is not liable for defamation to Mr. Depp, and therefore, by definition, she has not acted with actual malice, and based on the court's rulings on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court to award attorney's fees against Mr. Depp.
Oh my God.
So with that, Your Honor, I'm happy to answer any questions the court has.
That's
but
fine.
that
Thank you,
covers it.
sir.
Thank you.
Yes, sir?
I like how,
Your Honor, I will be brief in deference to the court's time and the jury's time.
uh-oh, here we go. It's like there was no
What
evidence
Mr.
at all.
Rottenborn said about Mr. Waldman's allegedly going to the LAPD about perjury is a complete non sequitur. If they thought that that were somehow improper conduct, they could have included it in their counterclaims. They included everything else but the kitchen sink, and most of it was thrown out. There was nothing in there about Mr. Waldman going to the LAPD. So that is a very clear
Grasping at
non
straws.
sequitur red herring
Yeah.
distraction. Number two, when Your Honor ruled on summary judgment on the issue of the counterclaims, Your Honor was dealing with a different standard and a different evidentiary record. At that time, Mr. Waldman had not testified, which is material. Mr. Waldman has now testified for purposes of trial. We have his trial testimony. It's very clear that he did not act with actual malice. They didn't even argue that. So that's pretty clear. And again, this is consistent. The third point is that it's all about games. They didn't sue Mr. Waldman on the three statements. They didn't try to fill the hole. They've been telling us for a week that they're going to call Mr. Depp to try to fill the hole in their counterclaims. They didn't do that.
Yeah.
And it's very consistent with the game playing. Let's go into court after the police have found no problem.
Multiple
And
times.
after witness who had no relationship with each other said there are no visible marks. Let's not give Mr. Depp's lawyer the required 24-hour notice before the TRO. Let's march into court with our publicist, with our lawyer, with our best friend who no longer talks to her. Let's get a TRO. And when the Me Too folks say, why are you taking $7 million from an abuser? They said, I didn't take money from the abuser. I gave it all to charity. Well,
But that
they
didn't happen.
I don't think anybody should feel bad about them stiffing the ACLU, given what the ACLU did in this case, which is a monstrosity.
True.
But she did stiff the sick and dying. So
Actually
it
true.
is gamesmanship. And that's what
Fuck
she's
'em.
doing here today. But the law is the law, and they have not fulfilled their burden with respect
Jesus.
to the counterclaims. There is virtually no nexus between Mr. Depp and Mr. Waldman as to these statements at issue, except for the fact that he is an attorney, and that is not sufficient. In
Yep.
a case where they have not even established that Mr. Depp was aware of these statements. And they knew that they couldn't do it, and they didn't even try. And it's more of the gamesmanship when Ms. Heard plays word games with Mr. Depp about, oh, I didn't punch you, Johnny, I just hit you. Imagine if the shoe were on the other foot and Mr. Depp, a man, was saying to a woman, oh, woman up, I only hit you, I didn't punch you. And when it was chilling, when she warned him on the tape,
That's
you go
true.
tell a judge, you go tell a jury that you, a man, were abused. See if they're going to believe that.
Uh-huh.
It is an
My
abuse
man.
of the system, and she's done it throughout. Finally, Your Honor, and Mr. Rottenborn makes an excellent point with which I agree, which was that with respect to each of the three statements, Mr. Waldman was clearly identified, even by the tabloid that printed these, well within articles that had both sides represented, that he was Mr. Waldman's attorney. Even the reader of a tabloid understands that when you're getting statements from attorneys, it's going to be forwarding their client's point of view.
Obviously.
Mr. Waldman is not the only attorney who has spoken out. Robbie Kaplan, who was Ms. Heard's second attorney. So Ms. Heard started out with Eric George. He made comments to the press. saying-
Objection, Your Honor. Again, this is so much further beyond what Your Honor is addressing.
I'm
I would
finishing
ask
up,
that-
Your Honor.
Okay.
I'm finishing up. My point, Your Honor, and it's on point, is
Oh,
that
boy.
Mr. George made statements supporting Ms. Heard's position. Ms. Kaplan made very clear statements supporting her client's position on the merits, and so did
Which would
Mr.
be
Waldman.
obvious.
But everybody knows when reading those that those are statements by partisans. So for the
Yeah.
reasons that we've stated and the reasons set forth in the brief, we respectfully submit that the court should grant the motion to strike, or in light of the fact that Mr. Depp may reappear, at the very least, take these motions under advisement until the close of all evidence. Thank you.
That would
All
make
right,
sense.
thank you, sir.
Yeah, that would make
All right, in
sense.
this matter, I've reviewed all the defendant's evidence
Oh,
as to
okay.
her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are outside the motion to strike, and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered in a motion to strike. Having said that, we went down that legal
It's like
road
fair
on Friday
use.
as far as the slap defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the three statements that are at issue in the counterclaim, ruled that they were not opinion at the demur and at summary judgment. So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may, and usually are, relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship, is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay? Thank you. Is there any other preliminary matters before the jury?
Yes, Your Honor.
So they're going to have to keep fighting it out. They're going to keep fighting it out. Yep. That's it. In my opinion, I think that it's not surprising that they're not going to strike it out and just say all that, because it's going to be harder to figure out whether he made those statements, like if Johnny Depp told him to or not. I think that's basically what it is. That's kind of what I'm assuming. Yeah, the battle continues. Yeah, it's like Amber's counterclaim will go on. Yeah, because they haven't presented all the evidence. It makes sense, right, that that's the case, because the Johnny Depp's team hasn't even presented all of the evidence in the first place. Like, that's why they have, like, over 10 hours left of people to talk about it and things to look at, etc. So that's what I would say. Well, let me go back. I'm going to look at the rest of this. And so is this good or bad? I would say it's not good. Is it bad? It really kind of depends, because all she's saying is that they're not deleting the case. Do you see what I mean? Like, yeah, it's yeah, I feel like, yeah, they're not deleting the case that Amber Heard has against Johnny Depp for defamation. Which, like, yeah, it's not bad. I don't necessarily think that it is. I don't think that it's good either. I think that it's a less than preferable outcome. I mean, I think a lot of people would have wanted to have it striked, but it seems unlikely that that would happen because all the evidence hasn't even been presented yet. Does that make sense? And I don't see this loss yet. They'd try to finish this today and said they get under 10 hours. Yeah, of course they do. Yeah, it makes sense. Missing point of this, if they call Johnny or it moves forward, there are hours left, they're trying to bait them. Oh, yeah, of course they do. And that could be the case. Yeah, they could try to call Johnny up and make that happen. Judge wasn't against the outcome, but wants the jury to decide. This wasn't a loss, really. More content. Yeah, I don't know if it's going to be that much more. I'm not sure. But then he released recordings and stuff. How can they be false? I mean, everybody heard exactly what happened. Because he's talking about two separate things. Basically, they're suing him for what that Waldman guy said. And what I find to be odd about that is that I personally don't really think that it did that much material harm, because after a lot of the posts for, the justice for Johnny Depp type stuff happened, they happened primarily in response to things that Amber Heard said, not things that he said. And I think that they can prove that with the graphs. I already looked at the graphs, and that's what it showed. This is not the closing argument. Yeah, no, I know it's not. Yeah, that's what I mean. Of course not. Why are they striking? Are they scared of something? Sorry. Well, I think that they're striking just so they can kind of move on, right? And focus on their case, right? I mean, of course they're trying to get the opponent's case thrown out. I mean, I think that kind of makes sense, doesn't it? Yeah, absolutely. And harsh reality for her, no one cares about her. Sorry. Well, no, the thing is, like, as I said, it doesn't really matter what happens in the court because it's the court of public opinion that I think this case really makes the biggest difference in. And I think that's why Johnny Depp pushed so hard to have it be put out in front of the audience, right? Is so people could see what was perceived to be an injustice. I think that's the entire point. Now, I think also it's a little bit not insensitive, but it's disingenuous for Rotten Boy to say that Johnny Depp was a wife beater because of what the UK trial showed, because my understanding is that it's different. Like, the UK trial was that they were not liable for calling him a wife beater. It was not a trial to determine the truth of the matter. Like, I'm pretty sure, I don't know necessarily because I didn't follow this very closely, but that's my understanding of what it is. So, yes, okay, that's what pretty much everybody's saying. So, yeah, you can't say, like, well, because somebody calls you that means that's what you are. Just because somebody is legally able to say that about you does not necessarily mean that that thing is true. So I find that to be ridiculous. And also, this is the United States. Why are we using the legal system of another country as a gold standard to judge guilt here in this country whenever we use two different legal systems? How does that make any sense? You know, obviously there's things that are different that we don't agree with, and things that this is not the best way of doing things, or that's what we would have done already. It doesn't make sense. Also, I think that calling, Waldman Johnny Depp's lawyer, that was referred to, the article that was written, that was referred to, he was referred to as that. Like, obviously, that's how people knew him, but as far as I know, he was not speaking as Johnny Depp's lawyer. He was speaking as himself. And the article that was written called him that because that's what he was known as. And clearly that's what the relationship was. I'm pretty sure that's not what he wrote. Good technique for Johnny's lawyer to speak freely and remind a jury why they're there. Yeah, exactly, sure. The judge in UK, rumored to have family ties with his grandchildren, Amber Heard, retired and expected after trial. Enough said. It's impossible to say. All I'm really trying to get at is that I don't think the ruling of the UK trial has any... There's like no impact that ruling has that I think should be like assumed as truth. Does that make sense? Like, I'm not going to listen to some UK court and just assume that that they did everything right. I mean, everything that I saw of that trial looked unprofessional as fuck. It looked like a circus. So yeah, big surprise. I'm not going to take that very seriously. I don't think anybody would. Let me go back to the rest of this. The evidence against you is substantiative true. The evidence was used to prove the term wife beater was not libel. Yeah, but like they have a different level of burden of proof over there is what I'm saying. And like, yes, maybe that is true. That is definitely true. And I don't necessarily know all the details, but I do think that it's different to say that somebody is something based off of the judgment of a court that's not even here in America. You see kind of what I'm saying? I find that to be ridiculous. And the judge for the UK trial wasn't fair to Johnny. Well, of course they weren't. And I think the reason for that is because, there's a lot of cases where people don't get a fair shake. And I think it's obvious that they weren't fair to him, because if they were, why would he push so hard to have everything televised? It doesn't make any sense. Yeah, it makes no sense. And take off your damn tinfoil hat from what? Oh, me? Oh, is it me or somebody else? No, I don't really feel like that at all. I feel like, doesn't it sound odd that people are using the justice system from a country that people don't use here as a rule for determining guilt? Isn't that weird? I don't know. I find that to be very, very concerning. I don't think that's a good way to handle things. It's like, why would they know? Like, well, let me explain, right? Yeah, it's English common law. This is not the UK courts do not operate the exact same way. They don't have the exact same type of judgments that American courts do. And also a big factor with this is that in the UK, they don't have the First Amendment. So this is a completely different paradigm. And no court ever ruled you as a wife beater. It's not a ruling anywhere. The language was used disingenuous and ridiculous degree. It actually became self-parody. Yeah, of course not. UK common law standards from UK law do influence US law? I think that they do, absolutely. And I think that it's a difference between 10% different. I think they're 90% the same and 10% different. But I do find it to be disingenuous to say that, the ruling from a court from another country that we actually don't do proceedings like that here should be used as a standard. I disagree with that. I think that's silly. That's basically it. Let me say that. Would you say the same for Nuremberg trials? Well, no, because those were universally accepted by all countries in a way that individual court cases for two people were not. How could you compare the Nuremberg trials to Amber Heard calling Johnny Depp a wife beater? That's silly. Yeah, and also that was I think that was pretty much an international thing. It wasn't just people in that one country. Well, it's again. People need to have, they have to make an extreme example because it's harder for that to happen and harder to make sense of it. And that's complete bullshit. They don't accept it by two countries. I think that all I'm saying is that I find it to be odd that this guy can make statements and say this kind of stuff about Amber Heard. And he was clearly making the statement. I think this is one of the big factors. This is probably the main thing that I think is that it seemed very evident that Waldman thought to know and had every reason to believe that what he was saying was true. He did research on it. He looked into it thoroughly. This was his opinion, and that's what he thought. And so there was no malice behind this because it was true in his mind. And I don't think that it was also reckless to say this because he had reviewed a lot of evidence about it because he was Johnny's attorney, just like what they said. So that's what I find to be very weird about this is how is this not him making a statement that he believes to be true? How is this any different than any of Johnny Depp's lawyers not getting sued for defamation because they repeat what they've researched through working with Amber Heard? You see what I'm saying? I find that to be very odd, and I think that's I think that's stupid. To be honest, I think it's fucking stupid. That's it. Judge struck this. Amber could have automatically appealed, so this is good. Maybe that's the case, right? And they haven't even shown all the evidence, so that's important to go there. To go there as well. Amber thinks that he was the abuser in her mind. Would that make her statements non-malice? I think that a big difference between that is the fact that she actually was a first-hand witness of it, and Waldman was not. So, for example, Waldman was told all of these things. So, for example, if somebody like that Rocky Pennington girl or any of Amber's friends had said this about Johnny Depp, I think that you'd have a much more sticky situation because you'd be going off of what they were told by Amber Heard, and so they were just repeating what they believed to be true. But Amber Heard experienced it directly, so I think that the evidence of the matter of the fact, did it occur or not, is actually more important than does she believe it to be true. Because Adam Waldman was a third party. Amber Heard was not. She was involved. Do you see what I'm saying?